I was here for her a Ghanatube, so would offer snowy. Remember my car by a bachelor way, so much as to say, dear. Now, but then some I would draw I coso, ever or my name with elbow. Now, so we know and quino, and Jaffonity, Dimechi, Nankoti, Simbia, El Coso.
Ghanaians, in the past week, we've been subjected to a cloud of noise that has swirled around our republic, some of it coming from the outside, cloaked in the language of concern, but steeped in condescension. And much of it also rising from within, in voices that paint a suspension of the Chief Justice as though it were a political ambush, a witch hunt, a hounding of the very head of our judiciary. Both streams of noise are dangerous because both distract from the only thing that matters, the Constitution of Ghana, which is being followed to the letter in this matter. Let us set the record straight. Article 146 of the 1992 Constitution is not a footnote. It is not an advisory clause. It is the supreme law of the land, binding on all, from the clerk of the court to the highest judge of the land. It lays down with absolute clarity what must happen when a petition is brought against a justice of the superior courts, the heads of our independent institutions, or the Chief Justice herself. Citizens submit a petition, the Council of State examines it with the President. If it finds a prima facie case, in this case, in the case of the Chief Justice, the President has no discretion but to set up a committee. And once that committee is constituted, the President may suspend the office holder until these matters are concluded. This is a constitutional design. So when petitions were filed against Her Ladyship Justice Torkonoo, and when the Council of State found a prima facie case together with the President, acting under Article 146(10)(a), did exactly what the Constitution gives him power to do. He suspended her and allowed the committee to do its work. That is law. That is due process. That is judicial independence in action. Yet, fellow Ghanaians, instead of looking at it from where we have come from, instead of looking at it with the patience of respect for the process, we've been hearing voices at home and abroad declaring that the Chief Justice is being persecuted. Abroad, we've heard from the Bar Council of England and Wales and the Commonwealth Lawyers Association, who issued a statement last week demanding, not suggesting, not urging, but demanding that Ghana, quote, immediately and without delay, unquote, reinstate the Chief Justice. Such imperial arrogance belongs to another century. It has no place in a republic that has been sovereign since 1957. But equally troubling are the voices within, voices that know this Constitution, voices that know that this Article 146 process has been used before, voices that now cry witch hunts only because the one in the dock wears the robes of Chief Justice. Let us remind ourselves, when Loretta Lamptey, the head of the National Commission on Civic Education, had her issues and a petition written against her for misconduct, Article 146 was triggered. A committee was set up and she was suspended and eventually removed. The law was obeyed. Nobody declared that she was being hounded. When Anas Aremiyao's investigative expose captured High Court judges shamelessly collecting goats, yams and envelopes stuffed with bribes, petitions were filed. Article 146 was activated. Committees were set up and several judges were removed from offices. There was public outrage at their conduct, yes, but no one said the process was illegitimate. When Charlotte Osei, the then chairperson of the Electoral Commission, faced petitions alleging breaches of procurement law and abuse of office, again, Article 146 was invoked. A prima facie case was made against her. She was investigated and ultimately removed. The procedure has been identical. The debates were heated, but nobody dared to say at the time that the Constitution had been abandoned. So why, fellow Ghanaians, when this same procedure in the Constitution, the same Council of State, another President, acting within the same Article 146 process as is being applied now to the Chief Justice, are we suddenly told that this is persecution? Why do we pretend that the law is routine for others but extraordinary for the Chief Justice? If anything, the very fact that a highest judicial officer is subject to the same process proves the strength of our democracy. It proves equality before the law. It proves that in Ghana, no one is beyond the reach of the Constitution. Let us not deceive ourselves. The suspension of the Chief Justice is in consonant with the Constitution. It is serious, although it is unsettling. It shakes public confidence, but it is not lawless. It is lawful. And if we undermine the process with cries of conspiracy, we do more harm to the judiciary than the petitions themselves. For what is more damaging to judicial independence, to apply the Constitution as written or to suggest that certain persons are too sacred to be touched by it. Fellow Ghanaians, I submit that this is not a witch hunt. This is not a coup against the bench. This is the Constitution doing what constitutions do, providing lawful means to redress lawful petitions. The Chief Justice has lawyers. She has access to the courts. In fact, she has already sought redress at the High Court, the Supreme Court, and even the ECOWAS Court of Justice. The committee itself is chaired by a justice of the Supreme Court. What more evidence of due process do we need? And so to those abroad who issue communiques dripping with colonial arrogance, we say respect our sovereignty. And to those at home who are whipping up hysteria about persecution, we say respect our constitution. This country is not a banana republic. Ghana is not a colony. Ghana is a sovereign republic governed by a constitution that applies to all. Let us not be hypocrites. We celebrated when Article 146 removed corrupt judges. We nodded when he removed Loretta Lamte. We debated but accepted it when he removed Charlotte Osei. We cannot now pretend that the process is illegitimate simply because it touches the Chief Justice. That will not be principle. That will be selective outrage. Fellow Ghanaians, let the Constitution do its work. Let it speak. Let the process run its course. Let the committee finish its work. And let the courts decide the applications before them. And when all is said and done, let us accept the outcome, whether reinstatement or removal. And the Chief Justice has the right to challenge the process when it concludes in court. This is the rule of law. That is sovereignty. That is democracy. And we must not do anything to suggest otherwise. Good morning and have a great day.
We will be making a lot more cases. And if you understand that due process means that the other person will have all the opportunities to test the law at every stage, then you know that the wheel of justice grinds slowly. But when we get to the point, it will happen. And then we do also think that we win every case, right? But our hope is that we win our cases. The job of a prosecutor is not necessarily to secure conviction at all costs. The job of a prosecutor is to do justice.
Can I impute the analogy that I've just learned from you now? That, for example, the Attorney General decides to discontinue a particular case. It's just not right, even the optics of it, for another body to want to go into it.
But not necessarily. I'm just saying that.
Because I was going to Iyoko.
It depends on what. No.
Okay.
Iyoko works for the Attorney General.
Makes sense.
The police works for the Attorney General. The NIB works for the Attorney General. The only institution that doesn't work for the Attorney General is the OSP.
Right.
So they do things for them. So if it's not within our mandate, and if it's within our mandate, there's that mutual respect that we're able to continue. So I'm just saying that your mind is being very mischievous. But
is it?
It's a good question to ask.
Well, your officers went to SML to pick up some equipment there. You tell us in the report that you've concluded. What should Ghanaians know?
Well, what Ghanaians should know is that when the legal year starts, it means that there will be prosecutions when we say we've completed.
Oh, yes. What did you find?
When the time is right,
I mean, you took we know that they were monitoring revenue. They were giving revenue assurances. What have you?
Well, at this stage, I cannot disclose any more to you. As you are aware, the OSP is a transparent institution, and when the time is right, you will notice that we are going to make it available to the public. We will tell you everything that was involved, why we are going to court, why this person is being charged, why this person is not being charged, and all that.
Were they did monitoring?
As I said, we cannot disclose anything at this point, right? Once the investigation is concluded, let's wait for the directives from the special prosecutor. I just give you a hint that usually when we say it's concluded, it means that there must be consequential action, and one of them is prosecution. Yeah.
You able to hear from now as mudi mwechi ekotie ensem no ebaye comment box no etwen for comment ebra na menjebre enkinkan emawo answer na message mo so make am say aha eye Ghanatube. So subscribe, hit on the notification bell for more updates. Makram.